Thanks, Jackie.
Fabulous. Thank you for that lovely introduction, Bernadette, and my sincerest apologies to you all for keeping you. Obviously, yeah, insurance is my area of expertise, but clearly not technology. And speaking of risk management, I sort of thought, well, it's quite nice that we've got great Minter Ellison, firewalls and everything up so that we can not have people infiltrating our systems, but sometimes it makes it a bit difficult when we're trying to deliver webinars. So thank you all for your patience. I do appreciate it. One thing, I had just seen a couple of messages come through, one being from Warwick saying that I'm only coming through on the video feature. So perhaps Warwick, if you can just send me a message just to confirm that you can hear me as well, that all is great. So otherwise, I think hopefully you can all hear me. So yes, I work at Minter Ellison. I work in the Insurance and Corporate Risk Group. So generally the type of work we do, the area that I work in is professional indemnity insurance. So great, thanks Warwick, you can hear me, great. So basically what our role is to defend people who are sued, and often it doesn't necessarily mean that it's a litigated matter. So some matters are just where you get a letter of demand from someone, but we often act for people who are sued. That's generally the type of work we do. So I'm not sure how many of you, if you do have professional indemnity insurance, but generally, if you're practicing outside of the school, I would expect that you would ordinarily have your own professional indemnity insurance to cover you against those sorts of claims. If you are giving your advice within the school environment, you'll find that your advice will generally, or your professional services will generally be covered by the school's insurance. So, schools take out their own insurance in that regard, and then the government has its own arrangements in respect of insurance. But I think we're going to look at that in a little bit more detail in one of the later sessions. So what I wanted to do today was just have a look at a bit of an overview about what risk management is, both I guess for you in your professional advice that you give at school to students, and then also for those of you who have a practice outside of school, or as well as, or instead of providing it at school, for those of you who might be retired or who have done something, do a little bit of work in both realms. So we'll start with that. The type of claims that I've had some experience in is litigated claims against schools and universities in the Supreme Court, County Court, and in VCAT. So if you're not familiar with any of those jurisdictions, I'm very happy to hear for you, because it means that you haven't had the pleasure of going there yet. So essentially, they're the sort of main jurisdictions that I've had experience in. I guess, is it possible to get a show of hands about, first, I guess, who practices only inside of school hours, so who only gives advice in respect of to their current students? Perhaps if you could raise your hand. Okay, and right. Okay, well that's 8 of you I can see, so 9, a few more coming through. Excellent, okay. Well, it seems that at least half of you, that's sort of the only advice you're giving. And are there any of you there who give advice both at your school and also outside of school? So, in terms of students at school, and then you also have your own private practice that you might give to students outside of school? Okay, seems to be a few as well. So look, like I said, I think the advice that we're going to give today, or the pointers, I guess, in relation to risk management, really go across both of those areas. So for both kinds of practice, being the practice that you run at school and then your own private practice. So hopefully this will be useful for most of you there. Livy's just asked about past students. So I understand that perhaps you might have given advice to students while they were at school, or maybe not even given advice while they're at school, but then once they've left the school, they then come and sort you out for advice. So I think in that instance it would be your own private, it would seem to be, or it's certainly arguable that it's your own private advice, because it's not in your role at the school to provide those services to current, it would just be current students, I would think. But it would just be a matter for the school generally as to whether there's, whether you would be covered under the school's policy. There might be a general acceptance that, look, if you give advice following they're leaving school, if they're part of the school alumni, as you say, Zeb, that it could be a continuation of that advice. I guess, like I said, we might cover that in a little bit more detail in the next session as to the distinction between the two. And it seems like it's going to be a pretty important topic. So I think the next series, the next webinar that we're looking at, is talking about giving advice online and avoiding issues in that respect. But it seems to be something that you've raised today that's quite important. So I think we might make that the focus of the third session, which will be covering yourself and making the distinction between past students and current students, and whether they are would be covered under your insurance policies as well. So we can certainly look into that. And I see that there is a growing expectation for you guys to do that. So that's interesting as well. So we'll certainly make that as part of the next session. But what I might focus on, I guess, is just generally when you are giving advice, be it to former students, current students, or people that you haven't taught, but you're just approaching in a private to provide private advice, some risk management tools to help you with that. So I guess we'll go through the slides and have a look at what we'll go through this session. So we just, the purpose of this particular session is, talk about your role in managing risks associated with your giving your professional careers advice. So we'll talk about what risk management means, why it's important, the potential avenues for legal liability, and we'll sort of draw on some of the examples I've seen, in my practice and that we've seen in our practice in the group. Areas that might give rise to claims and complaints. So again, we'll draw on some of the experience of what we've seen in terms of, file management and issues with, not confirming things in writing and those sorts of things. We'll go into that in a bit more detail. And then I'll try and give you some practical tips on how you can manage the risks, and so put some procedures and practices in place to help protect yourself. So obviously the first aim is to try to reduce the likelihood of the claim, but in the event that a claim is made, and whether that claim is without basis or even if it is spurious or vexatious, it's still important to be able to produce the paperwork to say, well, no, I did tell you that, and this is the advice I gave. So we'll talk about that in a little bit more detail. So with the next slide, hopefully we'll just have a quick look at a quote that I came across, which I thought was kind of interesting, because part of a lot of the work we do is learning from others' mistakes. So one of the other areas I practice in is professional indemnity insurance for lawyers. So I see a lot of cases where lawyers have maybe missed things or overlooked things. So it's quite helpful for my practice. But I think we're, as human beings, we do have this tendency. We are able to learn from the mistakes and experiences of others, but sometimes we're disinclined to do so, as you can see there. So I think one of the main things to take away from this today is to certainly use these kind of seminars and opportunities to speak with your colleagues and share some war stories. And we are human, so no one's perfect. We do have we can make mistakes. So I think it's important to share stories, learn from each other, and to try to develop better risk management strategies moving forward. So I guess following on from that, if there are issues that you come across that have raised concerns, I think share them with Bernadette, because they are certainly matters that we can address in sessions such as this to sort of assist you to provide a good quality practice and sort of assist others that are in your field as well. So what does risk management mean for you? The focus of this today is avoiding professional legal liability, so for the advice you give to clients. So there are obviously a number of potential legal liabilities, but today we're going to focus on avoiding professional legal liability. So that'll be, you know, failures to give proper advice and those sorts of things, as opposed to, you know, personal injuries, and I'll have a quick chat about that shortly. But basically, we want to provide good quality and well-founded advice. So that's making sure that, you know, you've done your research, you've provided documentation about the appropriate courses for particular students, whether you've got a questionnaire that you fill in, that students fill in, making sure that you know, sort of is quite thorough, so that you know as much as you can to provide good quality advice that's well-founded on that information. I guess understanding that there are risks inherent with every client. You know, we all know as students sometimes have different expectations about their own level of achievement, and parents may be different again. So, you know, understanding and just accepting, I guess, that look, you know, there's a potential, and particularly in the world we're living in at the moment, that legal, you know, people using the legal channels to air their grievances is becoming quite popular, and probably keeps us in business. But you know, there is a potential risk when you're giving advice. So you know, those sorts of considerations is just accepting that. Definitely having the right qualifications would be a good risk management strategy. So one of the things we always say, and I think I'll go into it a little bit later, a bit more detail later on, is definitely stay within your area of expertise. You know, that's one of the areas that we see claims arising from. So just using the law as an example, you know, if you're a tax lawyer, you shouldn't be giving advice about, you know, land, you know, sort of issuing caveats over land and those sorts of things. And it's the same thing when you're a careers counsellor, you know. So if you feel like you might be straying into unknown territory, you're best to say that. And if you're providing advice on careers, you know, you can always caveat things and say, look, you know, this is a relatively new area, if it is, for instance, and, you know, there hasn't been much published about, you know, what kind of career opportunities there are for it. I'm not particularly familiar with it. Those sorts of things, making sure that you, you know, protect yourself and make sure, rather than making sort of grandiose statements and those sorts of things. So I've put there that we should avoid needlessly risky clients. Now, obviously, that's a little bit trickier to do in the school environment, because you I guess, are required to see the students that are at your school. So I guess that one is particularly focused on your private practice, for those of you who have that as well. You know, and sometimes risky clients aren't apparent from the get-go. It's as you sort of get to know them and you get to find out a little bit more about them that they probably it becomes apparent that they are risky in terms of their, you know, you can probably tell the ones that you feel like you need to make a file note every time you have a discussion with them. But you know, if it's possible to do that, you know, that's great, but it might not always be possible for you in your practice, particularly your in-school practice. And then the last point, obviously, is having procedures in place to protect yourself in respect of the advice you give, and we'll go into a bit more detail about that shortly. So, why risk management is important to you. I think the level or to which professional advisors are being held has increased quite dramatically after some pretty high-profile corporate crises, such as James Hardie and HIH collapses. Like I said, in the legal sphere, you might have heard about the Clayton Utz matter. So basically, Clayton Utz were the lawyers for in the McCabe case. So that was the Big Tobacco Company case where a former smoker was suing Big Tobacco for you know, causing her lung cancer, and the lawyers for Big Tobacco came under significant scrutiny because they shredded documents, and I'm not sure if those of you heard about it, but that was quite scandalous. So, you know, having, and obviously that firm didn't have great risk management strategies to protect itself from, you know, that occurring. So one thing that these corporate crises have led to and scandals have led to is increased scrutiny from insurers and regulators. So, before an insurer will agree to insure you, they might require you to provide evidence about your risk management strategies and how you protect yourself against claims. So, one of those benefits, I guess, is having, you get lower premiums if you can, you're required to pay lower premiums if you can demonstrate to your insurer that, you're taking steps to protect yourself. So, and this is particularly important for those providing advice out of school hours where, you're responsible for obtaining your own insurance. But again, this, in terms of what insurance you're required to obtain and those sorts of things we'll talk about in one of the upcoming sessions. So the next point, I guess, clients are measuring quality and compliance. Again, probably not as great an issue for you, for those of you who are providing advice in the classroom because, your clients don't necessarily have many options before them as to who to go to for advice. But particularly when you're outside, building up a good reputation and those sorts of things, word of mouth is very important. So, if you're not providing, don't have great risk management strategies, and, obviously it affects your reputation and you're less likely to be referred work out elsewhere. So, that's quite important to keep in mind. And that sort of links in with the importance of developing a sustainable and reputable brand. How do you want to be viewed by your clients and potential future clients? So having good strategies in place is important for that. And then I guess the main thing is probably accidents and mistakes, poor management. They can all be costly to you, obviously, with a claim or complaint made, in terms of the hard costs that you might have to pay. And again, this is not really, if you've got insurance outside, generally that will cover it in-house. You won't be required to, pay out of your own pocket, but still, the school that whether you're working for or their insurer, it can be quite costly to do these. So, agreed, record keeping is very essential, and that's going to be one of the main focuses of the procedures that I talk about a bit later on. So, and so as well as those hard costs of paying out claims and the increase maybe that you might have in insurance premiums and excesses, because obviously the more complaints that are made, insurers increase the premium and excess payable, and so that's another hard cost. But the soft costs are also almost as important. So, the time that you'll have to spend defending the claim or, speaking to your insurer and, perhaps appearing in court, and, those sorts of costs are really, they can be really taxing, emotional costs of having to go through it. So, that's a significant thing to be taking in mind as well. And as well, obviously, the threat to your brand and reputation, claims and complaints obviously have a significant effect on that. So one of the other important things to take into account. Okay. So we'll look at the potential avenues for legal liability. Again, focusing on the professional legal liability, so that's what, like I said, we're going to focus on today. Negligence is a big area, so that relies on you owing a duty of care to your students to provide good, reasonable advice. And if you breach that duty by failing to adequately advise them of their career options, what's best for them, you could be liable and have to pay damages that result from that. So some of the cases we see are students saying, oh, well, if I had have got this advice, I would have pursued this career option, and then I would have, passed law school and I would have become a lawyer, but instead, because you didn't give me that advice, I didn't do that subject at school, and so now I, can only do this degree, and as a result, it's going to take me another 2 or 3 years to become a lawyer, so you owe me the lost income in that time. So they're the kind of claims that might be made in negligence, and a similar type of claim might be made in breach of contract. So, you know, often they're made in the alternative. So in a legal proceeding, you might see a claim made that, you know, you owed me a duty and you breached that duty, or alternatively, we had a contract, so you agree, I asked you to provide certain services, i.e. career counselling, and you said, you know, agreed to provide those services, but you didn't provide the services to an adequate standard, and so as a result of your breach of that contract, by not providing those services, I've suffered a loss, i.e. loss of income, yada yada. So, you know, we do see some quite extravagant claims of, you know, students who, oh, 4 years ago you didn't give me this advice, but I would have then, you know, I would have passed Year 12 and got 99.95 and studied law at Sydney University and gone on to be a lawyer and earned X amount. So you can see often the claims can be quite fanciful. And much happens in the intervening period. It's not just the advice that they receive from careers counsellors, but you can probably see how that kind of a claim can be formulated. One of the other areas that we see professional claims coming up is breaches of the statutory obligations. So, you know, Fair Trading Act, Australian consumer law, those claims generally say, well, you know, under the Australian consumer law, you are required to not mislead or deceive me, and you said I was going to be a doctor and I didn't end up getting that, so now I'm, you know, suing you because, you know, X. So those sort of claims, again, they can often be played in the alternative. For the Information Privacy Act, we've seen a case where, and again, it's you know, this is a mistake that's probably quite difficult to avoid in terms of risk management strategies, but where a teacher was emailing another teacher about a student who they suspected was plagiarising, and that the teacher accidentally included in the body of the email copied the email talking about the student plagiarising to the entire class, and this was a university case, and so all of the students in the class saw that the teachers were talking about the fact that this student who was named in it had plagiarised. So, you know, there was obviously a potential breach of the Information Privacy Act, which requires you to keep, you know, certain information about individuals confidential. So, you know, that again, that might not be something that applies to many of you, because I can't imagine you'd be emailing your students too often. But keeping in mind with other students' email addresses, but, you know, just something to keep in mind is something we've seen. In terms of defamation and copyright, I think Paul Callenbach, who's a partner at our firm, is going to speak at the next session, so he'll go into that in the context of online technologies, so we'll stay tuned for that one. Just briefly, while we're talking about potential avenues for legal liability, I'll touch on the sorry, I'm just saying Libby emails students and parents often, you know, and that's something that's, you know, important to keep in mind. Like I said, I think it's hard to imagine a situation where you'd be emailing an entire class, and I think that's what happened in this instance. So that's where, you know, he accidentally copied in everyone else in the class, because that was something that may happen. But it might be something that you do as well. I'm not sure whether you might have cause to do that, but I imagine that you would, you know, email students and parents, but, you know, individually. But obviously, if it is something you do, definitely keep that in mind about just being extra bit careful when you do send a group email like that. So in terms of non-professional legal liability, so these are potential avenues that I think it's just important to be aware of, but might not necessarily, you know, have cause for concern. So in terms of from a professional perspective, but I also do a lot of work in personal injuries, so physical and sexual assault by staff members. So I think in that instance, it's really more about protecting yourself against scrupulous claims or those sorts of things. So, and I think when you're in a classroom, in a one-on-one session with a student, it can be, you know, quite difficult to do that. So just being mindful, we are unfortunately in an age where you have to be a bit more careful about the time you spend one-on-one with a student. So particularly where you might be providing services out of school hours at a student's house when the parents aren't around, I think, you know, just being mindful of those potential liabilities, because obviously, you know, a student can bring a civil claim as well as criminal action, but a civil claim in respect of any, you know, psychological injury that they say they've suffered because of a physical or sexual assault, which they can claim has occurred on one of those occasions. So, and again, damages will follow from that in terms of general damages for pain and suffering and, you know, loss of income and those sorts of things from, you know, not being able to work because they've suffered such an injury that a mental, like a psychiatric injury. So, you know, and those kind of claims can be very expensive and, you know, go into the hundreds or thousands of dollars or even up into the millions depending on the level of the claim. So, so that's something to be mindful of. And the other, I guess, occupiers liability, not something you have to worry about at school, although obviously if there's anything, you know, that that provides a hazard, you should obviously tell your school about it in terms of in your classrooms or offices. But again, you know, occupiers of premises have a legal liability to people who enter their premises, you know, to avoid injury. So again, if you're providing your services at your house, for instance, just being mindful that there might be an obligation, or there's certainly an obligation for you to provide a safe environment. So, you know, if there are, you know, tripping hazards or those sorts of things, that's something to be wary of as well. If it's in your home, sometimes your home and contents insurance can cover it, but I'll, again, that'll be something that's going to be covered in a later session for those of you who are providing services outside of school hours. Okay, so areas that give rise to a claim. Interestingly, the majority of the claims and complaints we see don't actually arise from the quality advice that's been given, but from the lack of an audit trail. So often what happens is the claim comes in, we'll see the claimant will say, oh, you know, I was never advised about this, or I never got this, but we'll speak to the teacher or the careers counsel or whoever, and they'll say, no, I did. I spoke to them about that. We had sessions. I had one-on-one sessions with them and mum, and I explained that, you know, VCAL was an option or VCE was an option. They decided to go to VCAL. Okay, well, you know, where's the evidence to support those conversations that you had? Where is the, you know, advice that you gave? Those sorts of things. And just because it, you know, when it's not there, it makes it that much difficult to defend a claim. So file management is the #1 issue that we find. So, you know, it can be tedious, it certainly is tedious, but I cannot recommend strongly enough keeping detailed records of your conversations with students and retaining those records rather than, you know, making sure they're kept in a safe space that they can, you know, that you can access if you need be in the future. Like I touched on earlier, providing advice outside of the area of expertise is a big issue. So make sure you stick with what you know. Cost agreements, it might be interesting, obviously, providing advice to former students. You know, I guess, you know, it will depend on whether you're providing that in what you're, you know, getting as part of your payment from the school. But if you're doing it privately outside of in your time, you know, are you expecting to be paid separately for that? If there is an expectation of that, then you need to be upfront about that from the start and provide, you know, a quote, and then, you know, then you can actually keep a record of that so that down the track there's no dispute, you know, oh, hang on, you said we would, you know, no, we thought this was part of what the school provided. Well, no, oh, hang on, you're not a school student anymore. So avoiding those kind of conflicts. And this is just asked about how long I recommend keeping files for. It is a tricky one. So one of the requirement under the law is that people bring proceedings within 6 years of a cause of action accruing. So that requires someone, you know, within 6 years to say, okay, well, this is the claim I'm bringing. So, you know, you should generally be quite safe within that, you know, to keep files for 6 years and no longer. The difficulty is that the courts are very lenient at times on what constitutes when the cause of action accrued. So, you know, ordinarily it would be when you gave the incorrect or advice, but you know, it's not always clear. So you might want to, you know, show that you've given advice quite a long time before the cause of action accrued that sort of led, you know, to this their complaint. So for instance, you might have given advice in year 10 to a student about something that happened, and then in year 12 they decided that they might say, oh, in year 12 you should have given me advice about you know, what subjects to do. And you might say, well, no, and then they might not issue proceedings for 6 years and after that year 12 date. The issue is that you'll want to be able to go back and point to your year 10 advice that you gave to a student. So my advice would be to keep the files for at least 6 years after you give your or the complete file for a student at least 6 years after the last advice you give to them. And honestly, if your record keeping allows you to keep it files longer, I'd recommend you do it, in terms of if you've got somewhere that you can archive things away for a longer period of time. You know, I think you should generally be safe with 6 years, given that's the statutory time limit that people have that's placed on making claims. But you know, I think that's part of just good record keeping practices, retaining those files. Maynard's obviously pointed out that CEAV has the record keeping pad, so definitely great to keep on hand. We certainly take Intralis and Notepad with us everywhere we go and make a file note of it. So I definitely recommend you do that. Now, when I've just seen that, I'm sorry, I probably should. After I finish this slide, I might hand it over to see if there's anyone else who wants to ask a question rather than doing it over the chat. But I've just seen that there's a question about how about when you have class sessions with students, it's difficult to keep track of everything you've said to each student. Agreed. So that is certainly difficult. I guess making a note for yourself as to the class that you gave or the session you gave. So if you can have an attendance sheet that you sign, that you can send around, people sign when they're there, then at least you'll know who was at the class, and you know, you can then make a note after the class, or you know, just attach a copy of the presentation you gave or something like that. I just think the more you can do to protect yourself, the better, because it just often comes up that, oh, you know, well, so-and-so wasn't there, and, you know, you should have done this and you should have been more proactive, whereas, you know, it's absolutely understandable for you to say, well, I'm one teacher teaching, you know, however many students. I can't be expected to chase up each individual student and make sure each individual student attended. But, you know, I just think to try to protect yourself as best you can, those sorts of things, maybe having an attendance sheet and having them, you know, just sign next to their name and making a note of what you talked about, you know, rather than putting a file note on each single student's file, or making a copy of that attendance sheet and putting it on a student file would be helpful. So that could potentially be, but it is a bit difficult because I'm not working in these situations. It's hard to understand what's practical. You know, sometimes you can, you know, I can suggest things, but the practicality of them might be not quite what you might expect. So so I think we were talking about cost agreements. Excuse me. So obviously something that's really important to keep in mind where you're expecting payment for services outside of what you provide at school. Failing to manage client expectations, and I guess client expectations is the student and their parents. You know, again, often the two might have very different levels of expectations. So, you know, making sure that at the end of your discussion with particular students, when you're having a one-on-one discussion, you know, just reinforcing any particular issue that you see. For instance, if, you know, during that session you can clearly see that a student has unrealistic expectations of what they're going to achieve, and what, you know, what they can achieve in terms of what you're talking, you know, just talking that through with them and making a note of that. So, you know, unfortunately it's sometimes unavoidable to fail to meet client expectations, because, you know, no matter what you say, they can often be unrealistic, but, you know, trying to manage them as best you can and just being mindful of that. Management of time-sensitive matters just really relates to making sure that if there's particular cut-off dates, applications and the like, that you've noted things in your diary, you've put reminders in place, those sorts of things is important. And then maintaining client confidentiality, again, like we touched on earlier, very important just to make sure that you're not discussing things with other teachers, and you're keeping things unless it's required, obviously, but you're just not going out and talking to your partner, oh, so and so student at my school, blah blah blah, because you just never know who's listening. We there's a pretty kind of legendary story that goes around the law firms about a poor graduate who's sort of the equivalent to a trainee teacher. In the coffee shop talking about this fantastic case they were working on and yada, yada, yada. And then, unfortunately for this poor graduate, they had the CEO of the company that they were working for sitting at the table next to them, or someone quite high up, and who reported back, and it was extremely frowned upon by the client. So, just being mindful of not gossiping about students and maintaining their confidentiality about those things. So at this point, I might just pop it on hold and see if anyone's got any questions that they might like to ask before I move on to some particular strategies and practices that you can employ to avoid these kind of issues arising.
Okay, everyone, we've got a moment here to take some questions for Jackie. So if you have a question, just put your hand up and we can give you the microphone. Thanks, Enzo. If you'd like to take the microphone.
Hi, everyone. Jackie, just curious to know about, you mentioned managing unrealistic expectations. We often see this in schools, and often we know from the sort of way that students are presenting their subject results that they may have totally unrealistic expectations. Can you give us some strategies on how you might actually deal with managing that so that we aren't putting ourselves at risk, please?
Yeah, thanks. And so that's a great question. Unfortunately, I guess in terms of strategies of dealing with them, in terms of what to say, it's probably not really in my area of expertise as a lawyer. But in terms of, I guess, trying to avoid a complaint or a claim down the track in respect of that, I would say that those clients are probably, or students, are probably the ones that should be red flagging in your mind your need to write down the advice and give it to them in a written form, so that down the track, because these students might be the ones that, oh well, but I said I wanted to do this, and you said that was okay, and you said that I could do that, and now I've lost the opportunity to do this other course. So I think as when you encounter that kind of student, and it might be more frequent than not, but that should really be a note to you to make really thorough file notes of those discussions and back up with your advice, because I imagine that the majority of the advice you provide is oral rather than written. But one of the things in those particular circumstances I would be really imploring you to do, I should say, is making a written note of that advice. So, this is what our recommendation is for you, for these reasons, and setting it out quite clearly so that down the track, if that advice isn't followed, or if, they say, oh, well, hang on, I wanted to do this, you can really clearly point to your advice and say, well, but we recommend that you not do that, or you consider other alternatives, because and I understand it's probably a very difficult, sensitive balance between not sort of dampening a spirit of the student who might have high hopes for themselves, and you don't want to be there being the one to sort of telling them, oh well, you've got no chance, so don't be ridiculous. But it is trying to balance that across as well. So I think those particular students, that's what I would recommend.
Jackie, is it to do around the idea of keeping a note of both the expectation of the individual during the session? So if they do make a claim, so we'll just take the simplest one. For example, they want to become a doctor, they want to undertake a medical course, but all the evidence that's been provided to date is clear that in terms of capability, that individual may not necessarily achieve it at the first point, and that is at the exit of year 12. So is it a recommendation then that in those written notes that there's some form of pathways planning that goes along with that aspiration, so that the practitioner is showing a practical course of action without necessarily squashing the aspiration to become a doctor, but also covering the practitioner by saying that this is only one step in perhaps a longer journey for you? Is that sufficient in the discussion to allow the practitioner to cover all bases?
Yeah, no, absolutely, Bernadette. I think that's a great practice to have. You know, just I can't stress highly enough, you know, making adequate file notes of your discussions with them and canvassing these issues, but, you know, as well as sort of setting out, look, you know, even if it's not advice that's sent to the student, if that's not the way you generally do it, again, although I do recommend that be done, that you can show that at the time you had proper regard to the fact that, well, look, this is, you know, this is the student's expectation, this is their capability at the moment. On that basis, this is, you know, why I recommend this course as opposed to that course. And, you know, because you want to be able to set the students up to succeed. You don't want to set them up for failure by, you know, giving them unrealistic, you know, sort of feeding that unrealistic expectation, if that's the way. So, look, I think, like I said, yeah, and like you say, Bernadette, making sure that you have just covered yourself in terms of, you know, thinking about all of the potential options for them. And also then if you communicate that in written advice, that's, you know, sort of the safest bet, I would say.
We might move on because I'm conscious of the time, and you've got a few more slides to cover. Thank you.
Excellent. I think I can probably whiz through these quite quickly because we have we've gone through it a little bit in the last slide anyway. So I guess in terms of file management, like I've said, keeping detailed, clear and accurate notes of your discussions with your students, you know, dating them, putting a time for how long you spoke, and that's over the phone, in person, you know, those sorts of things. I think the better, the more complete your file is, the better. You can't over record things, if that makes sense. So can't stress that highly enough. And you know, if it means you carry around a compendium with a notepad in it, like a CAB notepad, that's what I do every day. So I would recommend that you do that and start that. It's a good practice to get into generally as well. Again, if providing advice, do so in writing, and also make sure you retain a copy, because it's all well and good to provide advice in writing, but unless you can then produce it later down the track to show, oh, hang on, I provided that advice, you know, so try and keep a copy for your file of anything that you write to the client. So whether, and you know, that will depend on what process you have in place, whether it's, you know, if you do it electronically, filing it away in an electronic file, or printing off a copy of an email or a letter and putting it on a physical file, and keeping that for a sufficient period of time. Like I said, at least I think 6 years would be a good practice, but if you can do so for longer, I would recommend do that too. Retaining copies of all correspondence similar to the one above, and written documentation on the file, and retention of records we've covered. So retain those records for at least 6 years. If you can. And I think that was it from the file management perspective. Obviously, something else that might be quite helpful is if you've got more than one file, sort of, you know, or folder for a particular file, you know, keeping a record of how many folders are in the file, because, you know, they can get lost and misplaced. So just keeping good record keeping practices. But file management, I think, is the #1 issue that you need to be mindful of. the cost agreement, making a written agreement. I don't know if you've got a practice of having a precedent retainer letter, so that when you are engaged by a former student or you know, an outside a student that you haven't taught, you know, that you can provide them a copy of, look, this is the fees, that, you know, these are my hourly fees, or this is the fee, you know, it's a fixed fee of X amount, so that there's an understanding about what's going to be charged for what services, so that there is, you reduce the likelihood of a dispute down the track. And obviously keeping a copy of the agreement on your file, that would, you know, so that you've got a copy to show at a later point in time is ideal. Managing client expectations, so I think we've talked about quite a few different strategies that we can employ. Obviously providing timely advice, so making sure that when you say you'll do something, you do, and you know, so I often like to conclude a meeting by just sort of reinforcing who will be doing what by what time. So if you're waiting for a student to provide you, you know, their reports or something, you know, making a note of that, and you know, confirming that I won't be able to do anything else until you provide me with that. So just sort of reinforcing whose steps are being taken, so that there's no miscommunication, and the students don't have an expectation that you're going to be doing something that, you know, you're across purposes. And like I said, trying to do that preferably in writing is best. And then maintaining confidentiality, like I said, limit your discussions for your students and the provision of information to third parties. The more you discuss it and provide, obviously, the greater you open yourself up. So if you are asked by other, you know, schools or other teachers to provide information, you know, just have sort of a thought about, you know, what the purpose is behind providing it, and, you know, whether there's going to be any issues of confidentiality of students. I mean, I don't really suspect there is. Obviously, medical information is more sensitive than the information that you're going to be giving, and there's obviously a necessity for you often to discuss the student progress between each other and students' teachers, perhaps. So, you know, understand that that's something that's necessary, but obviously just keeping in mind who your client is. So, you know, if the students come to see you directly, that you're not discussing matters with their parents without their, particularly if the students, you know, of age, that you're not, you know, sort of going to their parents and talking to them about things, because, you know, that might be a bit of a breach of the student's confidentiality. So just being mindful of that, particularly for past students. And management of time-sensitive matters, like I said, confirming critical dates in writing and setting yourself reminders in your diary. You know, Outlook has a great function now that you can, you know, put dates in there and set yourself all kinds of reminders. So making sure you're not missing cut-off dates and those sorts of things will ensure that you're less likely to have any issues with claims down the track. So I think that that's it from me. I'll hand the microphone back over to Bernadette and to the room if there are any.
Well, thank you, Jackie. That was very thorough, but there might be some questions in the room. I know that I've got one for you, so let's see if you can answer this for me. What happens when, let's say, a student leaves and after a number of years then contacts the school again and perhaps is, you know, upset with the school, the way the whole school managed their process, not just the career side of things, and you're implicated in that whole mess, I suppose, or in that the dissatisfaction with this that the student has raised or claimed against the school, because I know we've had this with a couple of members. How does the advisor respond to something like that?
Yeah, and that's generally how it happens, isn't it? That you know, a number of years down the track where, you know, things for whatever reason, and honestly, not often because of the advice they were given at school, but for whatever's happened after school, it hasn't quite turned out, and it's like, oh, hang on, who can I blame for this? So let's look back at past teachers or advisors. So I guess if you've given advice as an employee of the school, I would recommend that you always discuss any issues with your principal directly and not respond directly to the student or the student's parents. So because often I find students and or parents will try to single out people and, you know, put you up against one another. So, you know, a counsellor and a teacher, and oh, she told me this, but that teacher said this. You know, so I think it's really important that as an employee of the school, that the school provide a unified response, if that's possible. But you know, I would always make sure that you say, look, you know, I've got your complaint, or I understand that, you know, you've got a query in this regard. You know, I'm going to forward it to our principal so that we can manage, you know, we can discuss it and, you know, provide you with a fulsome response in due course. So that kind of a thing, because there might be issues that, you know, the school might need to contact its insurer and, you know, and get that, yeah, rather than having you discuss it with them. So, and then obviously I would recommend that you just you cooperate as much as possible with you know, the insurer or the school to try to give that response. I guess it kind of gets a bit murky where, you know, you might have given advice to a student as a student, and then past students, they continue to request your, you know, your advice, and then there's a claim made down the track about the advice you gave while they were a student, and then when they weren't, and there's going to be all kinds of issues. So I think, you know, it obviously each situation is unique in that respect. So I think always the best option to do is to contact the school, because we often find that, you know, insurers will extend indemnity to the employees of the school when they've acted in their capacity as an employee of the school. So I think if you've given advice while you were an employee and further advice afterwards, it'd be, you know, unlikely that you'd be covered for the first lot of advice and then not the second. So you know, I just think that's always make sure that you're trying to provide a response, and sometimes that means that the response is a bit delayed, but if it means just providing, you know, working with your principal to provide like a holding response saying, look, you know, we understand we've received your complaint, we're looking into it, you know, we'll get back to you shortly, and touching base, you know, if you aren't able to provide a response, you know, soon, instead of saying, look, you know, we know, you know, we've written to you, you know, 2 weeks ago, we are still looking into it and we hope to have a response to you, because, you know, school holidays get in the way, exams, you know, everyone gets busy. So, but I just think, again, it's important about managing expectations, because if you let someone fester and they feel like you're not doing anything, that's when you sort of have issues that start to arise. So I hope that answers your question, Bernadette. If you need to clarify anything, let me know.
No, that covers it. Thank you very much, Jackie. Are there any more questions for Jackie from the room? Okay, well, silence means that you've covered everything, I think, Jackie. So, Bryony, if you could just move to the next slide for us, which I think is our evaluation slide. Thanks very much. And just before we say thank you to Jackie for the wonderful presentation this afternoon, given that she had such difficulties with the technology, we have an evaluation form there. We'd like all our members in the room this afternoon to complete our evaluation. It does help us to prepare webinar series for you, and from these evaluation forms we were able to put together this Keeping Out of Court series, which I think has been absolutely wonderful this afternoon. Thank you, Jackie, for a very thorough presentation. I think it helped to reinforce for us a lot of our code of ethics that we work to, and our code of conduct. But us, you know, having it from a legal perspective really clarifies it for us. And certainly when we went down the track of designing record-keeping pads for our members, I think we were right on key when we had those for the members to ensure that they were able to keep track of the conversations they're having with students. So if I could ask everybody in the room to raise their some applause for Jackie. I think she gave a fantastic presentation this afternoon. Thank you very, very much for joining us in the first of this series of 4. And in the next series, we will be covering on the 11th of June. The next one to cover will be around minimising risks when using online technologies. I think we've got vicarious liability up there, but we've covered a bit of that today. we'll certainly be looking at minimising legal risks when using online technologies, and we'll also be covering your in August. The next in the series will be covering your legal liabilities outside of school hours. So that's going to be another good one to attend, and that's scheduled for the 20th of August. And as always, you can book for the extra webinars that we're running. The next one will be from BTAC, and also for the rest in the series, you can go online now because they've all been posted up there already. So thank you once again, Jackie. If you'd like to take the microphone and just sign off for the afternoon, we'd appreciate that.
Excellent, great, thank you. It's so nice getting some virtual applause and some lovely messages. So thank you for having me. I do apologise again for the delay, but I can assure you Paul Callenbach, who's going to be delivering the next session about online technologies, is an absolute technology guru. So I'm sure he'll be on top of it all, and we'll make sure we're on time next time. So thank you again for having me, and please, I really do hope if you've got any feedback, please provide that, because we really are keen to tailor our sessions to suit your needs. So thanks again, everyone.
Thanks, Jackie. Rightio. Well, we'll leave the room open for 1 minute. If you could put a timer on for me, Bryony, we'll close the recording now.